Hello? Yeah, this is Bob. Yeah. No, I got one bar. I'm lucky I can hear you. I'm on 23rd Street. That's the Flatiron Building. But guess what? It's 1906. Yeah, well, it's interesting, sure, but there's not a lot to do here. I mean, the shows are very silly, and there's no television. But you are lucky. You can watch Media Reporter if you stay tuned right now. That horse really stinks.
Hello, and welcome back to Media Reporter. My name is Clifford A. Marin, and tonight my guest is New York Law School professor David Epstein, an expert in contract law. Tonight, we will be discussing some of the misconceptions and generalities that the common man has toward contract law. Now, I am a law student, and Professor Epstein is a law professor, as I just mentioned. So we're going to be talking about what the everyday man should know about contract law. Now, Professor, thank you for being with us, first of all.
Good to be here.
Let's get right off the bat here. In terms of contract law and misconceptions that people have, you always hear the difference of, or not the non-difference of people saying, well, my word is as good as whatever I wrote down on this piece of paper. So, A, is that a big misconception? And B, if it is, what is the big difference between an oral contract and a written contract?
Well, surprisingly, it's not quite the kind of misconception that you might think it would be. If anything, it's probably a more common misconception to think that if something isn't written down, that it can't be a contract, that you can't agree to do something orally and actually be bound contractually. With some rare exceptions here and there, you can. There's really very little in the way of law that says that you cannot enter into an oral agreement. It's something that in some small way we do every time we buy something. So that's the first thing to keep in mind, because every now and again people get into trouble over something like that, particularly if we're dealing with like small business people. They don't understand that if they've agreed to do something, even though it's not in writing, it still may be binding. There still may be a contract. There still may be problems if they don't do what it is that they had agreed to do. On the other hand, it's usually a better idea to have the contract in writing. When it's in writing, there's not going to be any debate about what the people agree. Well, there can be some debate. But in general, if things have been done properly, you can tell exactly what it is that both sides have agreed to. So, particularly if you are dealing with anything that's of any importance at all, you don't want to have it. You don't want just an oral or verbal contract. You do want the thing in writing.
Now, this might be too general of a question, but is there a certain threshold that within the law, I guess, of your recommendation or of your of overall thought of what should be written versus what should not be written, or when it's okay to not write something?
It's a hard line to draw. There are some things where it's fairly obvious. You just go in. I want to buy this thing. Won't be in for 2 weeks. Okay, you'll order it. It'll be here in 2 weeks, and then I'll come in and pick it up. I mean, you don't want to have a written contract every time you've got something like that. Right. You get to a level, particularly where you're talking about performance that's going to happen over a period of time, where you want to make it. You want to be clear what everyone is going to be doing. If you're buying something that's fairly large, like a car, a house, the contract should be in writing. There should not be anything that's open to debate. If you've got businesses entering into some agreements between themselves to supply things or provide services, it's probably a good idea to have things in writing.
Now, once we have that contract, whether it's in writing or orally made, if a verbal amendment is made to that, what type of legal binding is there to that? Or is it a better idea to have a written amendment?
It's always better to have a written. Simply because if you've bothered to have everything reduced to writing in the first place, it doesn't make a heck of a lot of sense to allow either parts of the contract or changes in the contract to be oral, because it undoes everything you had in mind when you decided that this should be written. When you can have something oral, when you also have a written contract, and when you don't, can get complicated. Basically, regardless, when you've got a written contract, the one thing that's not going to happen is you're not going to have a verbal agreement that can contradict that contract. So if, the perfect example would be, you're buying a car, and contract says that the warranty is good for 3 years. The sales guy tells you that it's going to be warranted for 5 years. Well, what he's saying is oral, and it's contradicting what was in the written contract. So that's not going to happen.
Yeah.
Sometimes there are additional promises. So instead, let's say instead of the car guy saying that, we'll fix this car for 5 years, he tells you that you can have free car washes for the rest of your life. Presumably there's nothing in the contract that says anything about car washes, so that you could argue that this is just this extra thing. And as long as it, for the most part, doesn't contradict what was going on, could happen. That's why we like to use what's called a merger clause. Now, what a merger clause says is that here's the whole deal, folks. This is the entire writing. This writing is the entire agreement between the parties. And sometimes they get a little fancier, supersedes prior or contemporaneous agreements. But you put something specific in the contract that says this is the whole thing.
Right. And then if you want to add something else, then you have to write an entirely new contract for that.
Well, what you would do is you could have an amendments clause, which would require all amendments to be in writing, signed by the parties. Sometimes the merger clause, actually, for the most part, the merger clause would probably even be enough for that, because it's saying here's the whole thing. And obviously, if you've got an oral change, that means it's not the whole thing. It's contradicting what's there. That helps protect against someone claiming that this completely separate extra thing that does not contradict what was in the written contract also took place. So a merger clause is something that should almost always be there. And if you are reading through a contract that someone's asked you to agree to, you don't have a lawyer looking at it instead of you, it's something to look for.
Right.
Particularly if promises, if you're a customer, the odds are that the promises were made to you. And you should be aware that, well, it may be hard to prove the promises. In any event, if you've got something like that in your writing, no court's going to allow anyone to even talk about these oral promises.
Right. And going with the idea of promises, I could say something to you, or you could say something to me. But what I said is not necessarily what I meant, and vice versa.
Right.
Now, when Nixon was in the White House, he used to use the term, I know what I said, and I know what I meant. But that seems to be ambiguous, and there's a big ambiguity there. So what is really the biggest point in terms of intent and what had been written or what had been said in terms of contract law?
Well, just the word itself has created an ambiguity. Sometimes the sentence could be drafted in such a way, and could be used incorrectly. So do you have to have both? And you didn't mean that you needed both. Some contracts, you know, occasionally those of us who draft contracts do shoot ourselves in the foot. And sometimes you'll have a clause on page 2 that says one thing and a clause on page 3 that says something else, and you end up having to fight about it. It is kind of amazing who will come up with, you know, well, it's what it says, but not what we meant. I can remember negotiating a contract years ago. I won't name the organization, but there was an organization that made a good part of its business was producing these forms, and I was negotiating to have these, for the rights to have some of these forms reproduced, and there was a dispute later on, and the person who was in charge of their documents actually did say that. I know what the contract said, but it's not what I meant, and this guy's whole livelihood was built around contracts and drafting contracts.
So it almost seems like that point it becomes irrelevant, regardless of what the person meant. It's
what the person meant is something that will only become relevant if the contract has been done badly.
Right.
If the contract has been drafted properly, if you're the person who agreed to something and the language is not what you meant, well, you've got a problem. You know, you've blown this thing,
right.
And if you were doing it yourself, maybe you should have had a lawyer. If you had a lawyer, he didn't do so well with it. If there truly is something in the writing that is ambiguous, that can have more than one meaning, and so that you've made room for someone to make this argument. Not so much it's, you know, I know what it says, but this is what I meant, but well, that could mean a bunch of different
right.
things, and this is the one that I actually meant. You end up having litigation over things like that.
Is there ever a situation where there might be, you know, more than a few ambiguities within the contract, that the contract would become void, or would the contract just go into dispute?
I've never seen it get so far as to be void. It will become a dispute. If it's about something important enough, and the disagreement is sufficiently serious, it can turn into something. Sometimes parties, you know, will act in bad faith and will try to give a meaning to a document that's just not there. And, you know, it's hard to take care of things like that. There's only so much you can do in the document. It is ironically just a piece of paper. But normally, if it's something important, what will happen is you'll end up having a big fight about it, instead of having parties who were just executing the contract and doing the things they were supposed to do. They end up fighting about what they were supposed to do. One misconception that I think even lawyers have is, you know, if the other side has drafted something and it's ambiguous, and if it was drafted clearly, it's not so good for me. What we agreed to isn't so good for me, but the ambiguity, if it was interpreted the other way, would be good for me. Some people will say, okay, let's
leave it that way.
I'll pretend it's not there. But what ends up happening is, instead of just going about your business under the contract, you end up with a fight.
Right.
Because there'll be a fight. If it's something important, the other side will not just, you know, walk away and say, well, okay, maybe it was ambiguous, I'll give you what you want. So,
and I guess the whole reason for a contract, I mean, is in case there is a dispute.
Contracts have a very important preventive aspect to it. In fact, if you've got litigation over a contract, normally, not always, but normally it means somebody screwed up. You've done something to leave room to fight about.
And you mentioned before, in certain situations, somebody might say, oh, I should have gotten a lawyer for this, or it would have been wise to get a lawyer for this. At what point, A, do lawyers come in, and at what point do lawyers really not need to come in?
Well, it is a hard question. It's almost a little bit like, you know, when do you need it in writing and
right.
when you don't. All of us sign contracts constantly without even thinking about it. You apply for a credit card, you've signed a contract. You buy a ticket for the airline. You've entered into a contract. You send something by UPS. You fill out their form, and on the back is contract language you've agreed to. Obviously, you're not going to bring a lawyer along with you for all of those things.
It'd be kind of expensive.
It would get, yeah, you'd have a lot of happy lawyers around, but yeah, I mean, it would get kind of expensive. I mean, even something like buying a car. I don't think too many people bring a lawyer with them into the dealership to review the contract. And I mean, arguably, maybe you should. I know some ugly things that have happened involving, contracts to buy cars where you're supposed to get the deposit back and they don't care that it says you're supposed to. They don't want to give it back. Again, it would get expensive. It's when you start getting into very expensive things. No one should buy a house, for example, without having a lawyer review the contract. If you're running a business and entering into some kind of a major commercial lease, probably should have a lawyer look at it. But obviously, on the other end, people don't have lawyers look at their lease every time they rent an apartment. If you are contracting to have some fairly expensive service provided, you want a lawyer to look at it. So it becomes a matter of degree. There are always going to be some things that no one would use a lawyer for, some things where it would be nice, it's just too expensive, and then there are the bigger deals. And sometimes it's hard to tell. If you've contracted with someone to rebuild your kitchen. Well, they're going to come into the kitchen. They're going to take a sledgehammer. They're going to, they're going to tear down the walls. It's probably going to cost you $30,000, $40,000, $50,000. I don't know anybody that brings a lawyer with them to the contractor, but what they'll often do is send the thing off to their lawyer to take a look at afterwards. And again, particularly when you're getting into business things and bigger things and major money, you always want to make sure that somebody has looked. You're entering into an employment contract. Day-to-day folks don't enter into employment contracts. Can even be a decent job paying a significant amount of money. On the level where you're entering into an employment contract, you're an officer of the company. You don't have to be playing third base for the Yankees to have somebody take a look at the contract. You're committing yourself for a period of time, and they're going to be telling you what you can do, what you can't do, and here's what we're going to give you for doing it.
Now, I'm glad you mentioned before, just to go back to the point of signing, let's say, a credit card agreement or airline tickets. I mean, there's a lot of fine print, in 4 to 6 font on the back of those agreements, and people just sign them without really reading them. Should they be reading the fine print, or would it get them all jumbled up, or would it get them depressed if they knew what was on the back?
Oh, it might get you for doing it.
Now, I'm glad you mentioned before, just to go back to the point of signing, let's say, a credit card agreement or airline tickets. I mean, there's a lot of fine print, in 4 to 6 font on the back of those agreements, and people just sign them without really reading them. Should they be reading the fine print, or would it get them all jumbled up, or would it get them depressed if they knew what was on the back?
Oh, it might get them depressed. I mean, at least in theory, if it's a consumer transaction, contracts legally are supposed to be written in a way that someone can understand what they're reading. A lot of people, it's true, don't read everything that's there. You really have to. You just don't know what is hiding in the fine print. When I lease a car, the guy already knows who he's dealing with, and he'll hand me the lease and go out for breakfast. I'm going to go back. I'm serious.
Yeah.
He goes out and he has breakfast.
Yeah.
He knows I'm going to sit there and I'm going to read through this whole thing. The average person doesn't do that. They should. Well, frankly, part of the reason I do it was because, if you screw this up and you're a lawyer, you look really kind of stupid. But it really is, it is binding. You never know what's going to be there. It could be something that is very important. May mean walking away. And that can be part of the problem. When you're talking about, say, a person going in, and the kind of contract you're talking about where, the business prepares a certain contract that their customers enter into, and it's got a lot of this fine print. Most of the time, they're not all that open to negotiating it, but still, you want to know what's there before you sign. You don't want to find out when things go wrong that there's this clause that you didn't even look at that puts you in a very bad place.
Well, is there any type of plea that somebody could say, oh, well, I didn't read it, or well, I didn't know that was there, or is it basically, enter at your own risk?
I didn't read it doesn't work. There are certain outs that have been deliberately designed under the law to protect consumers. So, for example, if somebody comes to your home and you sign a contract, while they're there, you have a period of time in which you can look at that contract afterwards and get out of the deal just by signing something and sending it in by a certain amount of time. Ironically, some people think that this law is broader than it is. That at any time you sign a contract, you've got this.
Right.
It's not true, but it is true if they come to your house. If you buy a car, the agreement usually says something about if the dealer is providing the financing. That until you're actually given what the financing is going to be, you can get out of the deal. Now, that was more a credit thing, and not all people do finance through the dealer. If you're using a bank, this doesn't work. But that's there also. So you do have some circumstances where you can, it's not so much I didn't read it, but in spite of the fact that it's there, you can get out. There are not very many things like that.
So it's best to know what you're signing.
Know what you're signing. If you're reading something that really disturbs you, and you're doing something that is not a very minor thing, and not too many people are asked to sign a contract that's not minor, ask for an opportunity to show it to your lawyer. Even if you don't have one, even if you're just going to go back and think about it. If you have one, all the better, or get one if it's something really important. If the person doesn't want to give you that opportunity, that's a warning signal. Something's going on. They don't want you to look into this further.
Right. Now, final question. We only have a few minutes left. But let's say a situation arises where you and I enter into a contract, whether it's verbal or written. Let's say it's written, so we have it binding between us, and I want to back out. What happens? Can I back out? Would I have any outs? Would those be provisions that would be written inside the contract?
Yes and no to all of that. Well,
it seems like the typical legal answer.
I mean,
right?
yeah. I mean, there can be contracts that do give you an out for no reason. A contract that would allow you to terminate without cause. Those are not particularly common for obvious reasons. They don't provide anyone with much in the way of protection.
Well, let's say I say to you, I agree to sell you my car.
Right.
And then all of a sudden, 2 days later, I get a better offer.
Right.
Can I?
And you've signed the paper.
Yes.
Well, it is a yes or no thing. The answer is yes with a but. I mean, yes, you can get out to some degree. In other words, nobody can force you to buy the car. I guess on the type of thing where this comes up the most often, you sign a lease on an apartment. You want to move out of that apartment before the lease is up. They can't force you to stay there.
Right.
So yes, you can always get out. The question is, how much is it going to cost to get out?
So it's, I guess, the classic yes with a but, no with an
Right.
if.
The but is you did sign a contract. It's very, very rare for a court to order someone to fulfill the contract, but if you've damaged the other party by canceling the deal, you may find that you have to pay. So let's say you agreed to buy a car from someone for $10,000, and then you discover that you can buy the car somewhere else for $5,000. Well, that's a big difference, and you may want out. If you cancel the deal, and the person you were buying the car from has to sell it to somebody else for $9,000 instead of $10,000, he's going to come after you for the $1,000, and under the law be entitled to that $1,000.
You still end up saving $4,000.
You still end up. It's something you would want to weigh. So it's important to know that yes, you can get out. That it's extremely rare to actually force someone to do something that they have agreed to do contractually, but it's likely to cost you, and you have to weigh the reasons you want it out against what it's going to cost.
Now, I think we have time for one last question. So what would you say is the biggest misconception to the layperson about contract law?
Probably the biggest misconception is something I think I mentioned earlier, that a contract is always in writing. A close second, and probably one that causes problems more often for consumers than businesses, is this idea that you have a certain period of time after signing a contract to cancel the contract. It's only for certain specific things where the consumer laws will provide for that. For most things, it's not the case, and there are a lot of consumers out there who think it is, who will say, can I get out of this before 72 hours? And often the answer is no.
Okay. Well, Professor Epstein, I see we're running out of time. This was very informative. I want to thank you for joining us tonight.
Well, thank you for having me.
And again, I'm Clifford A. Marin with the Media Reporter. We'll see you next time. Thank you.